Hi, my name's Tony Ridley, and once again thanks for joining us in the Crisis Leadership and Management Education tutorial series. In this section we're talking about roles and responsibilities of crisis management teams and the composition and structure for successful outcomes and preferred patterns and systems as it relates to individuals and representative heads. Precautionary tale, as usual, this is not a physical or geography based constraint. That is, they don't all need to be physically present. Therefore, everybody needs to lose the perception that it's a round table physical presence. That's no longer required and certainly not indicative of modern day crisis management anymore. It may under certain circumstances, but by and large it's an extraordinary event. Crisis management teams, where we've been speaking about the 6 to 8 fundamental representative disciplines and functionalities within the teams that are very much fundamental to the successful outcome of tried and proven crisis management teams. They range from chief executive unit heads to sales, marketing, security, compliance, and so on. And we've spoke about a number of those roles and functions in previous sessions and more coming up. However, in this one we're going to be talking about legal in terms of the legal representation or the advice or advisory. Now again, every organisation is different. Terminology composition may range from in-house legal counsel, trained lawyers, barristers, to external advisors on a routine or extraordinary basis, or worst case scenario is someone who studied law as part of their MBA, or you've been through the yellow pages and you're speaking to a legal counsel now as the crisis evolves. However, the representative roles and responsibilities, whether they be an external service provider, the individual that represents at the crisis level, or in a large corporate multinational environment, the legal counsel and or his or her subordinates, is that the first thing that they need to be responsible for is a legal perspective and viewpoint of the crisis as it relates to their legal exposure. Now this can range from anything from government statutes to common law, to regulatory issues, to potential litigation, and even internal standards, ethics, or considerations in international tribunals. They need to be able to they should be the person in the development and the maintenance of the crisis management plan, should be intimately involved in both the plan, the decision making, the degrees of risk appetite. You'll find many legal counsels are inherently not risk adverse, but certainly risk hesitant. It's their job unless it's otherwise dictated or experience-wise, is that they will often provide the voice of reason or the less risky exposure when it comes to the decision making. However, they need to be intimately aware of the crisis management plan, hopefully gone through simulations, had education, have met and worked with the previous team members before, all those sorts of things, because it will form not only a basic understanding of how it relates to the law per se and interpretations and how a jury or a judge may view something, or even a regulatory body, but it also gives them the guiding principles and the ability to either preempt or conform with what is the preferred decision-making process and structure. So the reason I emphasize that is because with their inclusion, they can often preempt and mitigate a lot of issues and assumptions that have been made in the planning process that when you come to a crisis simply aren't relevant. It's the plan was too risk adverse, or it was too the risk tolerance was set too high, or it was made without consultation to a particular regulatory compliance or a decision-making process. Again, a comprehensive plan should encompass as many of those points as possible, but because of inclusion, we'll make sure that legal certainly represented it, and they will also have an understanding of what has been included and or excluded, so as, again, you're not wasting time, effort, and resources going over old ground. They should be responsible for reviewing and the release of specific contract details. More often than not, and increasingly for larger organisations, there's always service providers or provision of resources involved. which may impact or be related to the crisis, and therefore the legal, if it does involve a vendor, a supplier, a distributor and so on, then understanding of the contracts, and most lawyers will tell you that the contracts are not as important as the relationship, and making sure that they've covered off on the technicalities of what's can be done or should be done, or the spirit of the agreement, whereas sales, marketing and other liaison elements will be working on the relationship aspect. So they should have access and understanding of all of the contractual agreements. And again, if you're using a third party or an outsource element or somebody that you've just recently included in your decision process, you have to have a mechanism for quickly and succinctly being able to communicate or distill the priority elements so they can quickly come up to speed and contribute to the team or the business or the crisis process. They should be able to provide advice on the compliance and regulatory aspects that we spoke about. So again, if this word picture and this description is not describing the individuals or the department's representative in your current crisis management or your expectation of crisis management plan, then you have the wrong people or you have the wrong department. Unless they can provide these functions and have this understanding, then you've either got the wrong level of individual or you've got the wrong construct for their legal representation, and or you've got the wrong departments. So make sure that you've reviewed or you consider all of these elements and make sure that this is what you're actually getting when the crisis evolves or is part of your crisis management plan. Anything less and you will either have delays, frustrations or outright failures. And also in terms of specificity, and in terms of particularly if you're a large organisation, whether you be a national or a state, federal, international, regional, whatever, is that each and every location has particular nuances, interpretations, precedences. All those things need to be taken into consideration. Whilst they may not know all of the specifics themselves, they certainly need to be able to either advise or reach out or engage or encompass those team members, as everybody else has sitting at the top of the pyramid, engage that particular advice, because again, you don't want to be making a decision that you see as being the ideal solution that affects multiple jurisdictions and multiple layers, only to find that 75% of those areas don't have the legal authority or right or latitude to implement those particular courses of action. As well as providing advice on disclosure agreements, whether they non-disclosure or patents, and a whole bunch of details on escrows for IP and all those sorts of things. Again, the legal counsel should be able to provide both consult, information, guidance, and a stewardship agreement to ensure that the organisation either doesn't compromise itself in a momentary point of frustration and decision making for long-term impacts and considerations down the track. So again, that objectivity is certainly required. The consideration now, again, one other thing that I neglected to mention here is that legal forms a number of silos. So there's criminal law, there's prosecutional law, there's a whole bunch of other specific aspects within the legal spectrum that when we talk about things like communications, release and so on, it may be a discipline that's not necessarily applicable, or it may be a skill set not held currently with your legal counsel or service provider or whatever the case may be. So also be prepared that you may have to, at stage, engage a subordinate or a peer or different subject matter experts in these areas, because indicatively you won't necessarily find it in one individual, irrespective of their experience and authority and seniority. There will more than likely have to be some consult or some secondary engagement for those subject areas, but they should be able to guide you on what is appropriate and legal and relevant for public releases and statements and online press releases and so on. Policies and procedures, how they relate to the organisation. Interpretation, we've spoken previously about finance. Legal may have, they may be in concurrence or they may conflict with financial opinions, but specifically if you're going to be making claims or you're activating specific requirements within policies as they relate to insurance, both during the event or post the event, again, legal will be a key contributor in this particular process. For many organisations, brand, intellectual property, protection of those things that you may seek recourse or damages or prosecution later on, or even in the course of a crisis, or it may be the result of a crisis. Legal will be able to provide you, or the legal counsel should be able to provide you with guidance, interpretation, understanding, and certainly a layman's perspective on certain misnomers and myths. Many individuals have a very low tolerance for what they believe to be a criminal offence, a legal case, a litigation opportunity. Lawyers and legal counsel are there to provide realistic evaluation and the prospects of success, precedents, experience, backgrounds, statistics, all those sorts of things that can be significant value to the organisation at any stage, let alone during a crisis, but it's certainly paramount. And last but not least, as I've touched upon, intellectual property as it relates to crisis is often an opportunity or a gateway for hasty decisions. So those are things that the policy wasn't right, or the plan didn't encompass this, or it didn't foresee these set of circumstances. Legal representation or consideration during a crisis can help prevent what may have been the best of intentions at the time, which could ultimately lead to a compromise of intellectual property, patents, and a whole bunch of other proprietary or commercially sensitive information that still needs to be protected, irrespective of the gravity and the nature and the composition of a particular crisis. So again, they should also have visibility and consideration for those aspects. That concludes this section on legal. Once again, thanks very much for joining us on this sequence of roles and responsibilities for crisis leadership management education tutorials. For further information and more tutorials and videos on this subject, please visit www.crisismanagement.tony-ridley.com. That's all for now. Thanks and goodbye.
Yeah.